Hello, my name is Andrew Stevenson and I am the Secretary of the Scottish Law Agent Society. I'm also a practicing solicitor and solicitor advocate, and I thought that it would be helpful to give a talk on a consultation exercise which has only recently closed and which has profound impact if implemented in relation to how we conduct litigation both in the Sheriff Court and in the Court of Session. Now, by way of background, there is an organisation called the Scottish Civil Justice Council, which was established by statute in 2013 and which comprises the Lord President and a Sheriff's Principal and Sheriffs and various lawyers, and also officers from the Scottish Courts and Tribunals Service, and also the Scottish Legal Aid Board. And the body it was originally in two forms, or in two sections, one governing the Sheriff Court and the other the Court of Session, but they were amalgamated in 2013, and they produce consultations from time to time which relate to the rules that they have, or often relate to the rules that they have drafted in relation to procedure and process. And in this instance, they have produced a consultation on what are called ordinary procedure rules. The Scottish Law Agent Society was one of, I think, nine organisations which I think responded, and these responses can all be found on the Scottish Civil Justice Council website, and they're definitely worth a look, because in my view they are generally not that complimentary about a great deal of what's in the proposed new rules, but I'll come on to that later on. I want to talk about our response because that's what I know most about, and the way in which responses were invited was that the council posed three separate questions and invited answers to these three questions. So the question that first arose was, will the look and feel of these consolidated rules provide court users with the simplified, harmonised and user-friendly procedure sought? So they're asking us to look at the look and feel. Now, our response started by saying that we're more interested in the substance of the proposed rules rather than their look or feel. And we also say in our response that at first blush it may seem that the simpler the rules, the more basic the rules, the fewer there are and so on, the simpler the procedure that results from the implementation of those rules. That may seem logical. However, our view is that this doesn't follow at all, and we've suggested that a rule which said the sheriff shall determine the evidence to be led at a proof is a very easy rule to understand, but it does nothing to provide a predictable form for how a proof will be conducted. It doesn't suggest any predictability whatsoever. And the parties themselves, the litigants, the ones who are funding the whole exercise, would have no say whatsoever over the evidence to be led, the evidence to be left out, and the cost of the exercise. And we feel that a rule such as that, and I should hasten to add, there isn't a rule like that in these rules, but there are some that are comparable, but a rule such as that would not lend itself towards or to simple procedure. The rules are certainly harmonised, So the question, as I say, is do these rules provide court users a simplified, harmonised and user-friendly procedure? Well, I've dealt with whether being simplified is of assistance or not. Harmonised, they certainly are harmonised, which I think is a good thing. So there is harmonisation between the Court of Session and the Sheriff Court, which is something that the Council has been looking to bring about for some considerable time. So yes, there is harmonisation. Of course, that begs the question of whether one should be having outer house business in the Court of Session where that business could legitimately be conducted in the Sheriff Court. And one has to ask whether, maybe in the longer term, whether one should have a structure, a system whereby any litigation that is within the competence of the Sheriff Court, and it gets wider all the time, actions for proving the tenor of a lost document, actions of reduction are now competent in the Sheriff Court under the 2014 Act. Whether such business should be excluded from the Court of Session entirely, which would leave the Court of Session with judicial review and some kinds of action of reduction and exercise of the nobile officium, which vests in the Court of Session, whether these should be the only forms of work, forms of business that are left in the outer house. But that's not something that's an immediate issue. It's something that I think may flow from harmonising the rules, but who knows. Going back to these draft rules, it's fair to say that a lot of the procedure is quite easy to follow. So that's to its credit that it is easy to follow. We also think that some of the reforms that are envisaged by these rules are actually quite good as well, because at the moment you'll know that where you have an action that's warranted, you have a year and a day from the warrant to serve the writ. Otherwise, your warrant ceases to be of effect. The instance lapses, as it's said to occur, and a year and a day we think is too long, and it's unnecessary that it be that long. Of course, it's always been like that, and in fact, it's a common law thing. I don't think there's anywhere in the rules that say anything about a year and a day. But it's just the law that you have to serve a writ within a year and a day. These rules change that, and they say that you have to serve within 4 months, and I think that's a good idea. A warrant becomes stale if not used within a reasonable time. We think 4 months is a reasonable time. 4 months, of course, is the time within which you have to lodge an account of expenses at the termination of a Sheriff Court or Court of Session action. I think 4 months is a reasonable period. We also think that it's not a bad idea that summonses and defences should not generally exceed 5,000 words. I think you can ask that it exceed the 5,000 words if there's reasonable cause for that, but 5,000 words really ought to be enough to state a case. So we think that's a good idea. We also think that it's a good idea that the same judge or sheriff deal with the action from its inception through to its conclusion. That is a more efficient system than one where you have a case calling before one sheriff 1 month, and it's continued, and it's a different sheriff the following month, and the third sheriff after that, and you're appearing in court, and you're having to explain to the sheriff or the judge, but if it's in the Court of Session obviously, the background to the action, and the sheriff is having to read the pleadings or look at productions and so on. So there's duplication there, and it's time consuming as well. In the ordinary court in Glasgow, that's how it was for years, until they started having specific sheriffs dealing with particular kinds of action, primarily family cases, commercial actions, and personal injury. But what's proposed here is that where possible, the same sheriff should hear the case, whatever type of case it is, right throughout. It's a good idea. Having said that, some of the other responses say that there is a resourcing issue there, and I don't know whether that's true or not, but I've no reason to disbelieve that. The answer, of course, is to provide more resourcing, something we've been talking about for years. The courts need more resources, but we think it's a good idea to have the one sheriff throughout the action. The third element in the question that I mentioned at the beginning was whether this was user-friendly procedure, and what we say in the response is that in order to be user-friendly, procedure has to be predictable, and they have to be predictable in terms of the timescales, the logistics, the mechanics, the cost, and without those factors, it's not user-friendly procedure. And what we've said in the response is that someone might be willing to spend £5,000 to defend or pursue an action, but not £10,000 or £15,000. So, whilst on the surface the language in the draft rules is user-friendly, the rules, in our view, do not lend themselves to predictability, and to that extent they're not user-friendly. We say that at the moment, where we have an adversarial system, where you have the parties pitted against each other as if in a game of tennis, and the sheriff or the judge is a referee, whereas we still have that system, the responsibility for the conduct of a litigation is essentially within the control and the power of the litigants. So it's up to them essentially as to how they present their case. The problem with these rules is that they seem to compel the judge or the sheriff to become active in how a case is presented. In other words, instead of sitting on the sideline observing and assessing and judging and determining a case, the rules seem to require the judge to take on essentially a participating role in terms of how the case is presented. And we think that's a very messy situation, and it confuses the roles between the agents or counsel and the judge or the sheriff. And there's nothing user-friendly about that. We have to think about the interests of litigants, our clients, and we have to say to ourselves, is it reasonable, is it a reasonable thing that they're not clear as to who has responsibility for deciding, for example, which witnesses should be led, which production should be lodged, and what's devoted to the case in terms of resourcing. We don't think that these rules are useful in clarifying who has the responsibility for presenting a case. And we've said in our response that the client who says, who are we calling as a witness? He or she's not going to be chuffed if they're told, well, it's up to the sheriff. That's not an answer. And of course, one can understand that members of the public will be reluctant to litigate at all if they don't know, or they don't have a reasonable idea of how long it's going to last, what it's going to cost, what the risks are, and so on. I mean, we all know it's difficult enough at the moment to predict these factors, but with these rules it will be even worse. Because at the end of the day, the loser in a litigation generally has a very hefty bill to pay, and they're generally not very happy. And we all know that those in that situation are prone to make a complaint. And as lawyers, we're already facing risks, which in my opinion are more serious than they were when I started 30 years ago. I think things are much riskier than they were then, and these rules will not help. The rules are clearly intended to introduce management, judicial management of cases, case flow management and active case management, which is fine if you have the resources to do that. I note that the Sheriff Principal's response makes clear that in their view there are not enough resources for all cases to be the subject of case management, active case management. There just aren't the resources there, and that point is raised in other responses as well. We all know that there are certain types of action that are more susceptible to case management than others. So the classic type would be personal injury actions. And when Lord Coulsfield produced his report years ago now, I can't remember how many years ago it was, but that basically identified a type of action, personal injuries actions, where case flow management was well suited to that form of action. These kind of actions are quite formulaic. They generally follow the same pattern, the same path, and the other point is most of them settle, which was recognised in the Coulsfield report. The problem is, however, that a lot of actions are not formulaic. They basically have a life and a path of their own. The example that we've given is, for example, a dispute over a house extension. A kind of action I absolutely detest, because we all know that if you've done that kind of case, it's very time consuming to prove each element of it, and where there's a dispute over whether work's complete, whether it's defective, whether there's snagging work that needs to be completed, these things all take a great deal of time to lead evidence about, and it can be quite expensive as well, and very time consuming. And sometimes you can have 3/4 of the claim taken up with one element of the work, and the other quarter of your claim is divided amongst a plethora of smaller items. Sometimes sometimes it's not economical to lead evidence of these smaller elements of the claim, so you don't bother, and you get an award which isn't the whole sum sued for, but it might be most of it. But the point is that if you're the litigant, you're the pursuer, you've got control over how how you prove your case, how much you devote to each element, how much time you're willing to spend, how much or how many witnesses you want to bring. And an action like that is quite a hard one to actively case manage, I think. And in addition, do the litigants really want it being managed like that? I think probably most pursuers would want to have or want to retain control over how they present a proof in an action such as that. If, for example, the sheriff decides that certain witnesses should be called and certain productions should be lodged, and there has, you need to bring in expert witnesses, or you have to bring in calculations and computations of various heads of loss. That could be very, very expensive, and it might be an expense that the litigants would actually rather not have to face or bear. So there are all these risks in actions such as that, and we don't think that that is a user-friendly form of procedure. The other point we make here is that the Scottish, if any of you do legal aid, you'll know that the Scottish Legal Aid Board requires you to estimate the probable cost of an action, and they will then put a case cost ceiling on your legal aid certificate. These new rules will make it even more difficult than it is at the moment to predict the cost of an action. There are within the rules what are called orders about presenting, or a section that's headed up orders about presenting information, and this lets the court direct the evidence which is led. This is a radical departure from conventional litigation, and it's something which, if introduced, we would have to really seriously warn our clients about, and make it absolutely clear to them that we as agents will no longer have control over how cases are presented. The judicial intervention that's basically facilitated by these rules is quite radical, and we have concerns about that. Do we really want such an interventionist system? A more inquisitorial approach where there is the possibility on one reading of these rules that a sheriff may require a party to present information from a specific witness where the party maybe doesn't want to do that. And one has to ask the question, who is it that's conducting the case? Is it the litigants, or is it the court? And the point also is that it's unreasonable for the solicitor to be deprived of the control of a litigation, but at the same time left exposed to a complaint by the client if it doesn't go the client's way. So these are all the problems that we think there are as regards the approach that's envisaged by the rules regarding whether there is likely to be simplified, harmonised and user-friendly procedure resulting from those rules. The second question that's asked is, are there any individual rules which you think users, an awful term that, why can't they just say litigants, users might find difficult to implement and comply with, and if so, what would you do differently? Well, one point we would make is we don't see that litigants should be forced to lodge summonses or defences online. The fact of the matter is that many clients, certainly many clients of mine, are not comfortable using online systems, particularly those of older years. They tend to be less comfortable using technology, and they struggle with online procedures. If these rules are meant to be aimed at the general public in Scotland, rather than professional advisors or Scottish Courts and Tribunals Service, then in our view allowances have to be made for those who are not au fait with online processes and who are more comfortable with paper-based systems. And in our view, they deserve to be served by this procedure as well as anyone else. We think there should be a choice over whether documents and evidence is submitted in electronic or paper form, and we don't think it's reasonable that that choice be taken away. Let me turn to some other points that are in here. One which has actually been raised in some of the other responses is the question about whether an action, or when an action, rather I should say, when an action is raised for the purposes of time bar. Now at the moment we all know how it works. It's very straightforward. An action is raised when it's served. That's why you get cases where sheriff officers are running around on the last day of the or the second last day, would it be, of a triennium or a quinquennium, trying to serve the paperwork. Once it's served, the action's raised. We all know where we stand. By contrast, draft rule 8.2 in these draft rules states that a case commences when a summons is lodged for registration. It also provides, however, at Rule 9 that the court will not automatically register a summons that's been lodged. If it is registered, the pursuer then, as we've said earlier, has got 4 months to serve it. So at the moment, whereas somebody knows whether an action's been raised because he's got the summons, under these new rules the position is far less clear. So at the expiry of the triennium or the quinquennium, a summons may have been lodged, which is adequate for the purposes of the rules for denoting that a claim has been commenced, but it wouldn't have been served, and it could take another, well, it would have to be lodged or have to be accepted by the court, and there could then be another 4 months before it's actually served. So that's a confusing situation, very unsatisfactory in our view. We think the current situation is far clearer for everyone, and that's a system that should be retained. Some of the terminology in these new rules we think is a wee bit unhelpful. So the worst one, the one that we can't really fathom at all, we don't see the point of this, is that the rules avoid the term evidence and favour the term information. Now, all lawyers know, and most members of the public probably know, that there's a difference between evidence and information. And to treat one as the other, or as a subspecies of the other, or whatever, we think this is pointless, and we think it's bound to lead to confusion. And we see it in, for example, Rule 28.2, where it's stated that the court puts on oath a witness who is to provide information at the hearing. Now the hearing, this is another terminology change. Instead of a proof, it's now called a substantive hearing, I think it is. Yes, substantive hearing. Why can't they just leave the existing terms alone? Everybody knows what they mean. Everyone understands them. They've been around for forever. You lead evidence at a proof. You don't lead information at a substantive hearing. These terms are, they should just not interfere with them. And the fact is, witnesses don't provide information, they provide evidence. And if you look at the standard text, walkers on evidence, it's not walkers on information. So this should just be left as it is. The current system is clear, and it's that submissions, written pleadings, oral submissions, they convey information, and the information may be right, it may be wrong. And the way in which that's determined is that there's then evidence led. So information means one thing, evidence means an entirely different thing. And that clarity should not be compromised, and it seems to have been by these new rules. Chapter 7 of the draft rules, this is the one that's called headed up handling of supporting information. We think this is likely to baffle party litigants and probably some lawyers as well, because there's a risk in our view that litigants will equate information and evidence. They'll think that their written pleadings are the same as evidence, and they're clearly not the same. So we don't see the point of confusing things. As I said earlier, we now have substantive hearing. Now, I'd said I think that seems to be the equivalent of proof. Actually, that's not quite right. It seems to be the equivalent of proof, debate, and proof before answer. And again, why on earth are we ditching these terms that everyone understands? Anyone who works in the courts knows what the difference is between a proof and a proof before answer, or a debate and a proof, or a proof before answer and a debate. These terms have well established meanings, they've stood the test of time, and anyone who goes into court should take the trouble to do a wee bit of homework, a wee bit of research, and work out what these terms mean. It's not that difficult. So we don't think it's unreasonable to expect party litigants to go in and, or to go before they go into court, to actually look up what the terms mean and learn the distinctions between them and how they should be conducted. We've said in our response that making language user-friendly can also be regarded as dumbing down. We think that's the case in this instance. Doing away with terms of art just for the sake of it serves no useful purpose, and there are other instances of that here. So, for example, the term motion is abandoned instead of, and it's replaced by application. Well, why not just leave it as motion? But anyway, the last question that was asked, it's asked here, is: can you suggest any additional rules or changes in layout that would improve these consolidated rules? Well, in fairness, the layout is actually very good, but it's not that's the issue. The issue is not in the lack of rules or the layout of the rules, it's in the effect of the draft rules as they stand, and in particular the confusing terminology and the inquisitorial role of the sheriff or the judge in terms of his or her management of the litigation. As I said at the outset, harmonisation of the rules, or harmonisation of procedure rather, by the rules is a good idea. We do think, however, it would be helpful to retain specific rules to cover specific forms of procedure. There are some types of action, such as, for example, multiple pindings, or actions of count reckoning and payment, which can usefully be the subject of particular rules, we think. We think it's handy. We think it's useful for those who are conducting that type of action to have rules that govern that type of procedure. So these are the points that we have made in our response. The full response, I've only just kind of summarised it, but the full response can be found on the Council's website along with the other responses, which, as I've said, are not entirely complementary, and in particular they seem to think that there's an undue burden being put on the judiciary, which I think is correct. I think it is. There's also resourcing questions asked, such as, would it be practical to have active case management of every single action in the sheriff courts or in the court of session? So, whether these draft rules ever see the light of day is another matter, but it's important, I think, to be aware of what may be in the pipeline and just be aware of the thinking of those who are ultimately in charge of the rules under which we operate. So I hope this talk has been of interest, and we'll wait and see if these rules materialise. Thank you.